just so you know. And we are unmuting now. Okay.
Hi, so Patrick Egan here. Welcome to Fox Rothschild. Many of you are from here and many of you have been here, but we appreciate your being here. The point of today's presentation is that there are many Pennsylvania inmates who have served long sentences, who are now reaching their end of life process, and who, without some assistance from the legal community, will die, unfortunately, in prison. And there's an opportunity to assist those people, but there's also an overwhelming amount of requests for assistance that come into the various nonprofits that are involved in the criminal justice reform, I guess, for lack of a better way of putting it. Preferred abolition myself, but that's beside the point. Within the system, who are receiving these requests, and it's using up valuable time of various staff attorneys who would need to be handling other types of matters, including many wonderful victories that have taken place in the last few years, in particular Commonwealth versus Lee, that has led to the decision that the second-degree murder in Pennsylvania life in prison is unconstitutional. The Pennsylvania legislature is currently screwing around with that and not doing what they need to do, but that might lead to other litigation. And I believe the Abolition Law Center was one of the leaders behind that particular litigation. And so kudos to them. That's going to require a whole lot of man hours, person hours, I should say, from the various nonprofits. And so one of the things that we thought would be a good idea was to train up some lawyers who are interested in doing pro bono service in this type of work, particularly because it is the type of work that is very discreet, in the sense that you only have a certain number of hearings that you need to deal with, and you only have a certain number of work to do, a certain amount of work to do, and therefore it can be done within what many big firms allow their associates and partners to do within their acceptable limits. Whereas when you get involved in some of these other cases, you can work for months and months, and sometimes the people who count the money don't love that. But anyway, I digress and give a long speech. We're going to start, which is wonderful experience of our own partner, Karen Davis, who has personally worked in a compassionate release case, however, in the federal system, but a lot of that carries over. And I think the personal benefit that Karen got out of doing that work is what we really want to get across. And then I will introduce our wonderful panelists. I guess I'll do it now before Karen speaks, which is we have Frances Harvey, who is the interim executive director of the Atlantic Center for Capital Representation. Frances is a very accomplished litigator at a very young age, having worked in a number of different cases that have accomplished great things for Acres clients, and before coming to Acres as an attorney in other venues. And Rupali, who is I don't know, what is your title at ALC?
I'm a staff attorney.
Who's a staff attorney at the Abolition Law Center. And I don't know anything about their history, and I didn't read it because I'm a lazy person, but is obviously wonderful and is here to impart their wisdom on these cases to you. So with that, I'll shut up and give it to Karen.
Thanks very much. And I'm happy to be here. I am Karen Davis, a partner here at Fox, and just want to talk for a couple of minutes about my experience with compassionate release. It was on the federal side, but I understand it's pretty similar. And the 2 points that I want to make are that you can do this and that you should do this. So I am an environmental regulatory attorney. I know nothing about criminal law. I know nothing about filing things with courts or, making an argument before a court. I signed up to do this compassionate release motion, and I found out that really it's very similar to anything else we do. You have to research the law, study the facts, apply the facts to the law, and make an argument. And there are all kinds of resources available through ALC and other places, all kinds of people who will be willing to support and help you. And it makes it very doable. And so despite not having any background or experience using the various resources that were available, I was able to secure the release of my client, who is pictured there on the screen with his mother. And I have to say, of all the work that I have done, and I do get a lot of satisfaction out of my work, this was very satisfying. And, you know, I think when you look back on your life and your career, you want to think about, well, did I ever really do something that made a difference for somebody? And I know that this did make a difference, at least for my client and his family. And that's, you know, that's the best you can do, right? That's the most. And for the people who are, you know, may listen to this rather than be here now, I just want to read the note that I got from my client's mom a year after he had been released. She said, I just wanted to let you know that client has been home 1 year thanks to you and has had his kidney transplant surgery, which the Bureau of Prisons was not willing to give him. And just want to say how thankful and grateful we are to you, and we'll never forget what you have done for us. And we're on our way to recovery. So I really encourage everybody to take one of these. It's something you can do, and it's something that is very satisfying to you. So with that, I will hand the program back over.
Thank you. Yeah, again, I'm Frances Harvey from the Atlantic Center for Capital Representation. I will pass around a little later sheet if you are interested in being on a listserv. When we get inquiries and think it's a good case to refer, we will send it out over that listserv. Please sign up with your email if you're interested in that, but I will, you maybe want to know a little bit more about what it looks like first, so I'll do that later. Okay, this is what we're going to talk about today. Why we need your help. The medical transfer statute. So we've been calling it compassionate release. It's technically called medical transfer, and we'll talk about why that is. The nuts and bolts of representation, what it actually looks like to file a petition and have a hearing, and some of the ethical considerations when you're working with people facing serious health issues and potentially diminished capacity.
I can just chime on and sort of add a little bit about my background. So I'm Ruth Holly. I'm a staff attorney at the Abolitionist Law Center, and we filed a compassionate release or a medical transfer for a political prisoner we had been working with for many, many years who was in long-term solitary confinement. And after he was released, we had individuals write to us and say, hey, I just found out I had this stage 4 cancer diagnosis. I'm not sure what it means, but I think I might be eligible for this law. I don't really know anything about it. Will you take this case? And so we did it. And after that, we had people writing to us from all over the state. And what we know from the numbers of who's actually been released since this statute has been on the books, which has been since 2009, is that maybe only about 70 people have been able to get released under this law. And when you compare that to, I mean, that's for a lot of reasons that I think we'll also go through. It's mostly, I think, because of the way the law is written and how narrowly the statute's drafted. But when you compare it to the federal compassionate release statute or the First Step Act, since it was amended in 2018, there's been like 36,000 applications under that law. So there's a lot of constraints under, for people to be eligible. But the one thing we know is that there's a lot of people who reach out to us, and there's not enough capacity of lawyers to take on these kinds of cases. What we know from doing them, I've participated in litigating about 20 of them, is that they're very straightforward. We've won almost every single one we brought when they're medically eligible. And they're very straightforward and they're very doable. So if you have capacity to take a legal learn, you'll see that the law is very straightforward. It's a matter of just getting evidence in one place and finding medical providers in the community. And so, yeah, and so I think this is also, the reason why there's so much demand and need here is that we have an older prison population, and it's going to continue to get older. We had this very exciting decision in Lee come down, which impacted individuals who were sentenced to a mandatory second-degree sentence. There is over 1,000 people who are serving that mandatory life without parole sentence for second-degree murder, which is an outlier when you can compare it to other states. I guess I know we talked about this earlier, but there's not a lot of, how many people here are doing criminal litigation? Okay, I'm seeing a couple hands, yeah. So I think what we'll do is also just make sure that we're breaking down the presentation in sort of a baseline way so people can understand them. But one of the problems with Pennsylvania sentencing system is that there's so many people who are sentenced to these life without parole or death by incarceration sentences. And in Pennsylvania, as you can see from the stat up here, there's over 5,000 people who are serving that life without parole sentence. And, you know, so we have an aging prison population. It's only getting older. And when we look at the numbers of who is entitled to possibly getting resentenced or another parole hearing in terms of the people who are sentenced to second-degree mandatory life without parole, of those 1,000, there's at least 600 who are over the age of 50. So it's a population that needs a lot of support in order to get relief, because when you're sentenced to life without parole or death by incarceration, what it means is that when you don't have a right to a parole hearing, there's really no built-in mechanism for you to be able to revisit your sentence. It's a final sentence, which means the only ways to petition to get relief if you're serving that sentence is through the commutation process, or it's through this statute, the compassionate release statute. So it's an important vehicle for people who are serving that kind of sentence.
Yeah, and just to talk about clemency getting pardon, it's not really a realistic option for most people. As you can see from the stats there, very few of them have been granted in the last few decades. And for people that do have a terminal illness, it takes far too long. It takes multiple years to get clemency. So for the population that we're talking about today, medical transfer really is the only option. Okay, I just also wanted to show this graph to show that it's not just the prison population itself that's growing, but it's the percentage of that population that is over the age of 50. In 1996, for example, 6% of the population was elderly, and now it's more than 27%. It's looking like it's going to get to at least a third by 2030. And then, yeah, why is this a problem? It's not just that there's a lot of people, but it's that medical care and aging inside prison is particularly harsh. Just from our experience with these cases, things tend to get diagnosed later than they would on the outside, right? They're waiting for specialist visits. They're missing appointments because the security that's required to go with them to the appointment isn't available. When they are brought to an outside appointment, they're handcuffed to the bed. Their family isn't able to help care for them. There's a lot of issues. There's actually a new podcast that came out. Did you hear about this? About the women lifers of Muncie and medical transfer from WHYY? I highly recommend. Do you remember what it's called?
I'm in it. It's called Dying on the
are?
Inside.
It's called Dying on the
Terry
Inside.
Gray at WHYY is doing and interviewed a number of women at Muncie. They talk about commutation,
Yeah.
how difficult that process actually is. They talk about compassionate release and what it's actually like to get sick and be old and try to access preventative care, which often doesn't happen, and what it's like to deal with a chronic illness inside. So yeah.
So yeah,
highly
if you want more
recommend.
detail about this, definitely listen to that. You can hear from the women themselves. And one of the things, the notable things that I learned from that was that studies have shown that 1 year on the inside reduces your life expectancy by 2 years. So when we're talking about, over 50, obviously on the outside, we don't consider that elderly, but in prison, it becomes harder every year. Okay, the statute itself.
So let's talk about what the statute is. So as opposed to a post-conviction petition where you're actually trying to amend the sentence someone's serving, what this statute does is it defers a person's sentence until they pass away. So if you look at the language that's on here, it says a temporary deferral is what happens of a sentence until that person passes away. So in effect, none of the claims under the statute require making any finding about any of the guilt phase aspects of a person's crime or what they do. There's no inquiry that goes into that at all. Instead, what a court does is it has to make a finding beyond, there has to be clear and convincing evidence that all of the elements of this statute are satisfied. And so there's basically two mechanisms to petition for relief, A1 and A2. We're going to talk about both mechanisms and how they're a little bit different from each other and when to find out which mechanism is going to be more appropriate for an individual. But I think sort of the high level important thing to know about this law is that it's extremely narrowly drafted because a person has to be dying. They have to be at the end of their life and they have to have less than a year to live. You know, we call it compassionate release, but it's really not that compassionate. You'll have to be so sick in order to get relief. So I think that's why this quote here from a former Secretary of Corrections, John Wetzel, said, you know, it's not compassionate, nor do we release anybody. So with that said, there still are a lot of people who are at the end of life and who require care, and they're not getting those needs met in prison. So let's talk about A1 and A2 and sort of what the exact requirements are in order for an individual to be eligible.
Okay, so this is actual language of the statute, as opposed to the summary on the slide before. Again, notice temporarily defer the sentence of confinement for the purposes of medical treatment or hospice care.
So for an individual who's seeking care under A1, that's an individual who has to have less than a year to live, and that determination is made by their treating physician. And so that's typically their physician who's at the Department of Corrections. So the way the medical care system generally works is that in Pennsylvania, there's state correctional facilities that are spread all across the state. An individual can be placed in any facility. It's not necessarily close to their county of conviction. They can be far out west. And typically the way that the medical care system works is that there's a medical director, and that director will be in charge of the medical care that's administered all across the facility. And then below them, there will be healthcare administrators that help with overseeing care that's given. But the medical director is the one who will make this determination. So there's also a requirement under A1 that an individual have no detainers. Sometimes individuals can have detainers if they were not a citizen at the time of their arrest, and there might be an ICE detainer. Sometimes there's detainers if an individual was accused of committing, for instance, like an assault against a lifer or an assault against another prison staff at another facility. That can lead to a local conviction in the county where they were residing, and that can lead to a detainer on the record. So you can't have any detainers, and it requires that an individual be housed in a hospital or long-term nursing facility. And there's no requirement that they be non-ambulatory. And so that's distinguishable with A2, which is even more restrictive than A1. Under A2, an individual has to be hospice eligible. So for anyone who hasn't had any experience with hospice, it's very strict about who can be a hospice patient, because really it's because of insurance. So there's very strict requirements about how sick someone has to be. And usually providers say that an individual has to be projected to live for less than 6 months to be hospice eligible. So this is even more restrictive, but what it allows for is for a person to be released to a hospice care location at a family member's home. It doesn't just have to be at a facility. So a person could go back to their family's home if they're hospice eligible, but they also have to be non-ambulatory, which can be a problem for some people who, who might be sick, but still have the ability to sort of walk and get around. So we'll talk a little bit about sort of what that requirement is, but generally speaking, when we're looking at these two buckets under the statute, a way to think about them is people who are hospice eligible are coming out under A2, and people who are not, meaning people who are sick but might not be at the point of being hospice eligible yet, would come out under A1, and they have to go to a facility.
Okay, again, this is the language of A1, the nursing facility or hospital. The other thing that we haven't mentioned yet is when someone's sentence is deferred, they still are put on an electronic monitor. So they're still under custody, but the zone of inclusion will be about a half a mile around their proposed location. So it's really, it's unfortunate, but they will still be electronic monitored. I haven't had an issue with it so far, but it can be burdensome if, you know, the facility isn't charging it regularly, or there's some things you have to follow up on sometimes. You know, it stops working and it flags it for the DOC that, you know, something's wrong with it, so.
I will say we've encountered some issues with them. A lot of individuals who are at the end of life will experience a lot of swelling and edema in their legs, which can sometimes interfere with monitors. So they can be moved onto people's hands if that needs to be an accommodation that's made. So there can be adjustments that are made. And I'll just note that even though a person's on a monitor, if they want to leave the facility with a family member or a caretaker, or if they want to leave their home to maybe, like, you know, go around town, just eat out at a restaurant, go to see the park or something, go to, like, you know, a graveyard, that's all permitted. You're allowed to leave and go anywhere you'd like within the state of Pennsylvania. You just have to call a number, call the person back in. So there is still freedom of movement, but in order to leave the state of Pennsylvania, you'd need a judge's permission. So I think that can be helpful to explain to family members so they can understand sort of that it's a requirement, but it doesn't necessarily restrict movement or times of day when a person.
Yeah, it's a matter of just notifying.
Does A2 require?
Yes, they both do.
Really?
Yeah.
Interestingly, under A1 and under A2, one of them says subject to electronic monitoring and one of them says under electronic monitoring, which from like a very textualist perspective makes me wonder if maybe it's not actually required under one versus the other. It's a creative argument that we've tried to bring because some people, especially who are from Philadelphia or who have Philadelphia convictions, will have family members from Delaware or New Jersey, and their caretakers want to take them in there. And we've really not been able to find a way to get them to family members' homes in other cases, even under like the parole statute. So it's an interesting area that maybe could be litigated further, but it's under both technically.
If they're still under custody, I've had an issue like with somebody who applies for SSI, but they're considered still institutionalized for all intents and purposes, like people who are in mandatory halfway houses. So I'm curious about that. And also for the payment for treatment, would they be medical assistance eligible, or is it billed back to DOC, or how does that work? Do you know?
Yeah.
So medical care when a person's in the DOC is all paid for by the state. And then upon their release, usually what happens is the prison staff will apply for them to be Medicaid eligible. And so if someone didn't have a lot of assets, doesn't have a home prior to going in, they'll usually be Medicaid eligible.
Okay.
And then that would cover their stay at a facility. And some people who have VA benefits or who are 100% might not be Medicaid eligible because of that, so that can interfere with it. And I've seen some people apply for Social Security once they've been released into a facility. But my understanding is that most of that is usually kept by the facility and it might only be a couple of dollars left on the other side of that.
But the person, oh, well, we're on A1. So if you go home for hospice care, for example, are you still considered under the custody? But you haven't gotten to include yet. So,
Are you still considered under the custody of the state?
oh, good. Okay.
Yeah.
Perfect.
Yeah, so we're just gonna go section by section and give a little more detail about each of the provisions. The first thing that you need to make a showing of is that the medical needs of your client can be more appropriately addressed in the hospital or long-term nursing facility. So how do you show that? We've done a really surface level overview of why treatment can be remarkably different inside and outside. But this is something that you should also try to really tailor to the needs of your client and their particular condition and what they can receive inside versus outside. So some of the things you should be thinking about, you know, how long does it take to get their medication? Are they getting their medication regularly? Is there hospice offered by the prison? A lot of them don't contract with hospice providers. What is the staff to patient ratio? A lot of times it's a lot better at a hospital or long-term nursing facility. The speed at which medical staff can respond to emergencies. So we have a client who had a stroke, and his cellmate had to recognize the symptoms, had to bang on the door, yell for help. They had to come over. The guard had got to decide, like, is this an emergency or not, right? Not trained medical professionals are deciding, is this a medical emergency? And by the time you get someone to treatment, right, a lot of the consequences can be much worse. So I think responding to emergencies can be an important one. Access to the bathroom. Are they able to get around on their own? Are they missing appointments? Like I said, a lot of times outside visits can be canceled if everything isn't lined up. And then are there other things that might not be the symptoms of their terminal illness, but are collateral issues that aren't able to be cared for in the prison? And a lot of times, you'll see people's friends and cellmates stepping up and caring for people for them, but it's not the same, right? They don't have the resources, they don't have the medical knowledge, and what they really need is a medical professional. So one thing you can do, you can consider hiring a hospice or palliative care physician to serve as an expert. And they can educate the court about, why that kind of care would be more appropriate. Maybe an expert with some who has experience with care in correctional settings could be even more effective and can really highlight that difference. Did you want to add anything?
Yeah, I just wanted to add, that under A1, you have to show the court that the care in the community is going to be more appropriate than the care in prison. And sometimes it seems so obvious, like, of course, the care in the community is going to be different, but it's really not at all to most judges, because the forum you have in these motions is the criminal court sentencing judge. And a lot of them, I think most of them, aren't really familiar with what happens in prison. And so it's really important for you to sort of have that understanding. And I think for a lot of clients, sometimes they will cope with the trauma of having to deal with a serious medical illness in prison, and will sometimes brush over problems. And so it can be really important to ask specific questions to get at some of those differences, because that can sort of be make or break between comparing, for instance, being housed at a prison specialized hospital or being housed at a facility here where there are some services offered, but it's not exactly the same. So finding out if there's specialized equipment at the facility you're trying to take them to that maybe that facility doesn't have could be important. Or just, getting information from an expert to kind of tease out what that actually looks like in practice.
We should also say a large number of our clients have some sort of cognitive decline in these cases, and that's another area where it's just if your client has some sort of cognitive decline, it's of course much more appropriate if they are getting treatment for that in a facility that has those programs and has those people available to help and is in an environment where those needs can be met. That can be a huge difference. Yeah.
Are there any resources like scholarly articles or any kind of studies that compare the, inadequate care that could maybe be used in lieu of an expert to educate the court. I know in the federal system, the Bureau of Prisons will come in and tell you they can cure cancer,
Right.
but I'm not sure what it's like in the state.
That's a good question. I'm not really aware of any good scholarly studies on specifically the Pennsylvania system.
Yeah.
I mean,
lot
we
of
all
this-
know it stinks, but it'd be
Yeah.
nice if somebody wrote about it.
That's true. Yeah, a lot of it, like Rupali said, is asking the right questions and then asking those questions of the facility and comparing them yourselves, unfortunately. But we do have some resources on memory care and the issue of ambulatoriness that I'll circulate to everyone. Okay, so how placement, hospital or long-term care nursing facility, you have to, as part of this, find a facility that is willing to take them, and that is easier said than done sometimes. There are, and again, we have connections at some facilities, at least in Philly, that have done this before and understand the statute and understand their obligations, and will agree to do this. But it's really up to you to make that connection and then get a letter from the facility acknowledging that they are willing to accept this person as a patient. They have the information they need. Sometimes you can have them talk about what care they offer that you can then contrast to the DOC, and that they understand their reporting obligations, which we'll talk about in a bit. Do you have any tips for getting placement?
Yeah, this is actually, I would say, the law is pretty straightforward. I think finding providers is probably the hardest part. Sometimes it's where the most manpower really goes. And I have had the most luck when a client's family member works in the medical field. Maybe they work as a hospice nurse, maybe they work in a facility as an administrator, and sometimes they're able to help and use their connections to try to get someone a bed at a facility. Because sometimes when you just cold call facilities, there can be a bias against people who've been incarcerated a long time, and working with someone who sort of has a connection already to a provider can help. So I've had some luck doing that.
Yeah. And we're not in this section yet, but I will say I've had the experience of trying to find a hospice provider. And if you tell them what it's for, they will say, oh, we don't serve that area. And then you call them back about someone else and they magically do serve that area. So it is unfortunately a matter of finding someone willing, but they do exist. We have successful placements, and we'll provide that information to you as well.
How's it been on sex crimes?
That's tough.
Yeah.
That's tough. I think in congregate facilities, it's really tough to place someone who might have reporting requirements.
Yeah.
And they might be a better candidate for a home hospice situation where they're at a family's home where there might not be kids or other conditions that might interfere with what those requirements are.
I had somebody recently who just had an old conviction, and his sister was just trying to get him moved from a bad nursing home to a better nursing home, and
Yeah.
just couldn't get it done based on the old sex crime conviction.
I still am aware of one person who did have a sex conviction where they were non-ambulatory, and because of that, the facility was willing to take them in. It just depends on the facility and maybe a person's abilities. And I think because a person's sentence is deferred, I actually am not sure how that interferes with their reporting requirements, if they actually do take effect or not.
Right.
But you're right to flag that that's
Yeah.
it's a tough situation.
Yeah, and to be clear, everyone is eligible for this regardless of, well, not everyone's eligible. The crime does not make someone ineligible. The conviction, the criminal history, but it does come into play. We'll talk about that in a moment. Seriously ill and expected by a treating physician not to live for more than 1 year. So we talked a little bit before we started about this, like how is that determined, right? How do you say with certainty someone has less than a year? And really what it comes down to is the person's DOC treating physician saying, I think this person has less than a year to live. And there can be complications, right? When someone has a treatment that isn't curative, but is life prolonging. And we can talk a little bit about that when we're talking about deciding between sections, but
The only thing I'd add there is that this is that language of the statute that a treating physician has to be
Yeah.
the person who makes that finding. And so typically when we refer these cases, if you were to sign up for a case, we would already have a one-pager medical narrative summary from the doctor at the prison who would say, you know, this person has XYZ conditions, these are their limitations, and I believe this is their prognosis. So we'll usually have a piece of evidence that already lays this out, so you don't have to worry about it. The harder cases are usually those where the doctor is sort of non-committal, and then sometimes it can be important to get outside records from providers who've seen that incarcerated person at a hospital and then talk to them because technically they would qualify as a treating physician. So yeah, we try to refer cases where people are already, you know, seriously ill. So there's evidence to establish this
Yeah.
problem.
How long does this process typically take if the person's prognosis is already less than a year? Like, what's the timeline?
So you can pull together a petition pretty quickly, and then a hearing should be set within 2 weeks. So it can happen very quickly if you're on top of it and you're able to find a facility. I would say that's the thing that's usually the holdup.
Yeah, and
Um,
in Philadelphia, they treat them like emergency hearings.
Mhm.
So when you file, you'll really get hearing right away, and then if it's granted that day, transport could happen as
Yeah.
soon as the next day. So they happen very quickly. Sometimes outside counties might take like 3 or 4 weeks to schedule a hearing, but they still move like very quickly, I think.
certainly within the year. Okay, we talked a little bit about detainers. Do you want to talk about this? Or do we need to say anything we didn't say?
Yeah, I think if you're in a situation where your client has detainers, there's going to be a document called a DC 16E. That'll be the one that will show you where the detainers are. Sometimes if a person is given consecutive sentences, meaning they might be given a sentence like life without parole for first-degree murder, but there were other charges that were part of that conviction, like for instance, maybe possession of an instrument of a crime and robbery. Sometimes sentencing judges will have those secondary sentences run consecutive to the first sentence, and they can show up as a detainer on someone's record. If you're dealing with that kind of situation where you have a detainer, just know that if you can't file under A1, you can file under A2. There might be ways to try to get the detainer lifted. If you're in that situation, look at the 16E and we can sort of help brainstorm ideas on how to deal with it.
Okay, so if you have a detainer from a different jurisdiction, whether that's another state, whatever it is, basically you have to notify them in advance and find out their position, and submit that with your filing. It doesn't necessarily bar relief. And the one case where I had one of these, I think it was New Jersey, they just agreed to lift the detainer when we explained the situation. So I don't know if you've had a problem with other jurisdictions before, but I found it's worked out.
What about ICE detainers?
We had a case once with an ICE detainer, and the person was really sick, and they just agreed to lift it. And after he was released and transferred home, I think he only lived for maybe like 24 to 48 hours. I don't know if that posture of how ICE treats these has changed since then, but I think there's just lawyers we'd reach out to, and maybe it depends on the situation, what they consent to, you know.
Was that under this administration or the last one?
I think it was the last one.
Okay.
Yeah.
Good guess.
Okay, undue risk. This can be a challenge. The statute says that the person's placement would not pose an undue risk of escape or danger to the community, and says the sentencing court shall consider the institutional conduct record, so that's any misconducts they have in the DOC, whether they were convicted of a crime of violence, but I think typically the judge will look at their entire criminal record probably, the length of time that they've served, and any other factors the sentencing court deems relevant, which can be good or bad. So in addition to the stuff that the statute talks about directly, you might want to highlight the nature of the misconducts. I think a lot of judges don't understand how petty a lot of the misconducts are in DOC, right? We see a lot of people getting violations for having someone else's paperwork or being on the phone too long, right? These aren't things that make someone a risk of danger or escape, but that's not necessarily going to be disclosed by the DOC. They will just say they have all of these violations. So you really, if it's something like that that you need to explain, make sure the judge understands that these aren't actually problems. Things that can be problematic if there is a history of escape, right? If your client has a criminal history with a lot of violent crimes, unfortunately, the judge is gonna consider that heavily. And a lot of what you want to bring in a challenging case is probably going to be their capacity, right? A lot of these clients, even if they wanted to go somewhere, they couldn't, right? Without assistance. So you want to emphasize, they have weakness on their dominant side from a stroke, or they are pushed around in a wheelchair, right? They're not going anywhere. And focus on just their capacity, they don't have the capacity to be a risk if the judge is concerned about this. So when you file one of these petitions, the DOC sends you 2 affidavits, one about what supervision looks like and one about their opinion on the person's risk. So it's usually pretty vague. It will say like, this person has 5 misconducts in the last 10 years. Often they'll say we don't have an objection, we don't think they're a risk, but not always. It just depends on the record. But usually it's not super detailed. But that affidavit will go to the judge as well. You could also consider hiring an expert witness here, a forensic psychologist, to do a risk assessment and say your client has, he's all good.
Yeah.
You have any other tips or things people should consider?
Yeah, most of these cases, your client has a violent conviction, which is why they're serving such a long sentence. And I would say that arguments like where you can very clearly say this person's been incarcerated 44 years, they're not who they were when they were maybe 19. It's been 14 years since their last misconduct. It's been, they've never had, they've been law-abiding since they've been in prison if they haven't had any criminal convictions. I think there's a lot of creative arguments that can be made here to sort of like create and emphasize the distance between violent behavior and like who they are usually as an older person who's sick. And I think judges are sympathetic and understand that when someone is older, that there's not a lot of recidivism, that, usually people are just trying to seek better care. So it can just be important to, I think, emphasize distance.
Mm-hmm.
And sometimes you can get people's records, they'll share their good conduct in prison, and that can be helpful also in this prong.
And then I should say also, if the facility specifically has, I know one of them has locked doors, right? Only the employees can open the doors, right? So that's another thing you can consider, just the number of people around in the facility. All right. We mentioned the facility obligations. They have to agree to notify the department and the court of any material changes in your client's health, or if the nature of the care changes, or other information, which is usually if the person's going to be transported somewhere. Yeah, you can have them acknowledge this in the letter they provide you. So I think what the nature of the care provided is getting to is if someone is restored to health, which I've never seen happen, but supposedly is a possibility. It is true that a lot of my clients at least have lasted longer than a year, just because of the different environment and the better treatment. So far, the DOC hasn't complained about that and we haven't run into any problems. So if it's just a matter of your client is lasting longer than expected, that you don't have to notify anyone, but, yeah,
So they don't call and say, why isn't he dead yet?
not so far.
Sometimes the prison lawyers do.
Yeah, well, they're kind of busybodies, but I have not had a judge concerned. And right, they're not getting better, right? And that's easy enough to show. Okay. So when you file a petition, you have to notify the Commonwealth, so someone in the DA's office, and then the Office of the Victim Advocate, so that they can notify any registered crime victim. And I think, at least in Philly and probably in other counties, they often try to find unregistered victims as well in case they have input. And they do have an opportunity to be heard at the hearing. In the cases I've had, the victims have not come in person, but the DA has reported what their position was. And again, we can provide that information if you have one of these cases of who to be contacting, at least in Philly. Okay, should we talk about A2? All right. All right, so like we said, A2 is for people that are hospice eligible to be transferred so that they can receive care from a licensed hospice care provider. Again, a lot of folks, want to be home with their families, and this can be a way for that to happen. I will say these are sort of bittersweet cases, but I have a lot of clients who aren't sick, who are serving life without parole sentences, and what they tell me over and over is, I don't want to die in here. And it's even if you're getting someone a week at home with their family, it's worth it to do because they get to be surrounded by their loved ones. So
It's so meaningful for people's families.
Yeah.
Like for them to be able to be there because for some prisons, they only allow one end of life visit. So you'll able to just see that person one time, and for them to have closure and sort of be able to be with their family and been able to do it a long time or their whole life. It's been, just so meaningful for family members, I think.
okay, so terminally ill, not ambulatory, and likely to die in the near future. We talked a little bit about what hospice eligibility means. Let's talk about, oh no, okay,
Yeah. So
we can talk about it again.
yeah, exactly. Hospice stays are usually more restrictive. And so what we'll do in order to determine if someone's hospice eligible is we'll get their medical records. That's usually one of the first things that happens in this process. We send the medical records to a hospice provider, and then they'll indicate whether or not they can care for someone. And then they'll draft us a letter, and it'll usually have language like this that we're able to file.
Okay, not ambulatory. So you can get creative with this, right? It doesn't mean literally they can't stand up or are bedbound. It could be that they are relying on a mobility device, or they can walk very short distances. The DOC's paperwork might have a box that's checked that says ambulatory, but it means, right, they can like walk across their room. It doesn't mean that they're mobile.
Ambulatory is not defined in the statute.
Yeah.
So it's up to your interpretation or how you want to argue it, what that really means. And so you can go to the next
Yeah.
slide. We reached out to this group called the Medical Justice Alliance. They're a nonprofit that will connect pro bono doctors to lawyers representing incarcerated clients to try to assist them in representation. So it's another way to get contacted to people. And they helped us draft this one pager to actually think about what ambulatory means in a medical context. Because since it's not defined, maybe we should think about how they use the term, which is often in evaluating whether or not a patient's going to get inpatient versus outpatient care. So this just has some questions to ask, but I think you can be creative in your argument if you sort of have this question of they have limited mobility, but they might be able to do some things, and how to argue what it is to be non-ambulatory.
Like A1, you have to show that the care provider can provide more appropriate care. It's a similar analysis, but again, you can also focus on the hospice specific services, which have to do a lot of times with pain management and also collateral services for family, end of life considerations, things that hospice providers are able to do that the DOC isn't doing.
As far as I'm aware, no facility within the DOC hires licensed hospice providers. Like they don't have them on staff. And that's one of the most, I think, compelling ways to just meet this problem. Their hospice programs are usually just other incarcerated people who will visit with people when they're dying to make sure that there's someone with them. And they're not necessarily trained in medicine. They're just other incarcerated people who might, like keep their lips moist or something, but they're not doing more than that. And so, when you locate a hospice provider, calling them to figure out what like psychosocial services they provide can be helpful to sort of establish that. And I think it's pretty easy to compare it to the care that's established.
Okay, so this mentions that also. Should we talk now about deciding between sections or? Yeah,
Yeah, about 15.
okay, maybe we speed along.
Yeah.
Okay.
It can be someone's home.
And usually the hospice provider will come, 3 times a week or a set number of days a week and provide their services. And you can get a lot of the same supplies that would be needed through that care.
For the home hospice, like normally you'd have to have like a social worker or someone like go and talk with the family and make sure they're capable of caring for the person. Like, do you have to establish, like go through all of that here?
There's not a formal process you have to show, but it does help to, have maybe an affidavit from the family member that's going to care for them saying this is my, this is what I'm going to do. This is what I'm able to provide. This is how I have it. Yeah, you do want to show that they're going to get other care as well.
Okay.
Usually like call a family member and make sure they have like a space in their home that's handicap accessible, that there's going to be someone who's around most of the time to help with the caretaking, and then they'll make that connection with the hospice agency themselves.
Okay.
Undue risk, same as under A1. You might need a little more details about the location of the care. I know in the case law, a lot of the bad decisions are based on proximity to the victim, or, you just have to make sure that the location is gonna work.
Yeah. And ultimately they're I think this is also the same. We can pass that that through, but I was going to say, ultimately these are mercy transfers. So it's really up at the discretion of the judge upon whether or not they want to grant it or not. So sometimes, if there's compelling victim testimony that they feel unsafe, if they know someone's been released and it's near their home, it is in the discretion of the judge to just not grant it.
Yeah. Okay. And the notice, you have to flag it for the same people. All right, let's talk about some of the practical steps for filing one of these. Like any case, you're going to want to do a complex checks, do a representation agreement for this particular issue. You have to get on their phone list. They will be able to put you on the list, your number on the list, so that you're able to have legal calls that aren't recorded. The main thing you need, the main release you need is the DC 108. It will allow DOC to give you their records, which includes medical records, but also disciplinary records and other records. And then for any outside hospitals where they were treated, they usually have their own releases. Rupali mentioned the DC 16E. That is a form you can get from DOC counsel that shows the structure of their sentences and if there are any detainers. She also mentioned the narrative summary. That's the document that's going to say this person has less than a year. We'll usually have that already. And then getting the DOC medical record fees waived.
They're only $25 to get their medical records, but the DOC is pretty cooperative, and they'll if someone's medically eligible, they'll waive them. So, just in terms of who you're working with on these cases, your opposing counsel is going to be the DA in whatever count the county of conviction is. And DOC counsel, you will work with them to help get the documents you're going to need in order to file. So you'll alert them as well when you file a petition. They're the ones who make sure they have the order, if it gets granted, and they'll help arrange for transportation. They don't usually appear in court, but they are important to sort of liaise with in order to get what you need in order to file.
They'll also provide a functional needs assessment, which talks about, what your client is able to do. Are they able to care for themselves in certain ways? Are they ambulatory? That kind of information. Okay, signing between subsections. Sometimes you're only going to have one option, but sometimes you're going to have to choose, and really the client's going to have to choose. There have been issues with the judge that most of these go to in Philly, where his understanding of the statute is that something like chemotherapy has to be discontinued for you to be eligible under A2. That is not the DA's position. It's not my position, obviously. But what really needs to happen is that you need to explain if your client is going to continue some sort of palliative medicine, that it is not curative, their life expectancy is still going to be under a year, and that it is treating their symptoms. But I will say, last time I was in court, he was directly asking the client, do you intend to stop this treatment? And so you may run into that.
I think you're talking about an important and delicate subject, and it's important when you get one of these cases to ask your client about their goals of care early on, when they have capacity, and to know what's important to them. For some people, it's very important for them to pursue as much aggressive treatment and all the treatment they can. And it's important to know that. And I think it's also something, we can help brainstorm or think through if you have issues with how to navigate it.
And as a note, your client can be granted release under A1, and then later, if they're eligible for hospice, can be petitioned to be transferred under A2. Okay. We talked about how you have to show clear and convincing evidence of each prong. Usually, in most counties, you will get a hearing, but you have to make sure, at least in your petition, that you're making the prima facie showing. Generally, what you're going to want to attach is a copy of the statute, the letter from the provider, the narrative summary giving that prognosis, the functional needs assessment that I mentioned, the sentence summary. Again, if your client is going to be at home, an affidavit from the person who's going to be their primary caregiver. And then if there are any gaps in what the evidence you have, possibly a declaration from your client or expert materials if you need an expert.
If you take one of these cases, we'll share a draft that's in Word, so you can use what you want from it. And I will say that in Philadelphia, often you don't have to put on testimony of witnesses in order to establish the different elements of it, but in outside counties, you usually do.
Can I ask you about the limited scope and when it's a family member who's contacted you because their loved one has decompensated so far that they're medically fragile, can't participate, are they otherwise incompetent? What do you do? You're getting
we'll
there?
get there.
Okay,
Yeah.
good. Thank you.
I don't have a good answer, but
Okay.
we'll get there. Like I said, you'll generally get a hearing. It will be, if the sentencing judge is still on the bench, it will go to them. Or the PCRA judge, basically the last judge that had it. In Philly, a lot of times the judge isn't on the bench anymore because folks have been in so long. There is one particular judge they tend to go to in Philly in that case.
Is it Palumbo?
Ehrlich.
Ehrlich?
Yeah, who understands these. Okay, so if you do have a hearing, invite family and friends or support people, make sure the court knows they're there. The people from the medical facility, if they have given you a letter, they don't need to be there, but they should be on notice that the hearing's happening, because if it is granted, they can be transferred pretty immediately. try to get updated medical information. You can usually get updated forms from the DOC. And they should be able to arrange testimony from your client if needed via video.
I don't usually put my clients on, but it's an
Yeah.
option. Usually waive their appearance.
Yeah,
Just because it's so fast. And
Yeah.
you prefer an emergency hearing over trying to coordinate.
right. Okay, so if it is granted, immediately notify the facility, the DOC, they're gonna want you to send them the order, you can send it to council. We'll give you that info. And the DOC will coordinate the transfer, the electronic monitor. It's always, as in any case with the DOC and the criminal legal system, it is good to be following up on things to make sure they happen as they're supposed to. If it's denied, you can appeal. You filed notice like any other case, request transcripts. It is, I'm not going to say it's hopeless. It's tough because, as Rupali said, it's really a discretionary act of mercy. And even if it seems pretty unreasonable, if the judge says, I have concerns about the risk, the Superior Court's not going to do anything about it. You can refile your petition in, pretty immediately if you want. You can say, there's been a change in his condition or this new fact. And a lot of times that will be more likely to be successful and happen in a reasonable time.
That's been my experience.
Yeah. Okay, we touched on this. The DOC should release the Medicaid number. If your client does have a work history, it's possible they're eligible for Medicare. If your client is going home and they are going to be taken care of by a family member, the family member can often receive payment for being a home health aide for that person. Yeah.
Pretty, maybe less than 5.
Okay. Sorry.
No, it's good.
All right. Well, here's the hard part, the ethics considerations. Confidentiality, you're dealing with medical records, sensitive medical records. Make sure that, you're only communicating it to people that have releases, that you're filing confidentially with the court. Do you have anything to add to this? I don't want to get to the
Yeah, let's
complexity
get to the diminished capacity question. I think it's a good question. Spend a little time there.
Yeah. Okay, so like any other case, this is the rule that applies. And the answer is not satisfactory, right? It's as far as reasonably possible, maintain a normal client-lawyer relationship with the client. A lot of folks at the end of their life, you have that diminished capacity. And in my experience, it's always, you're consulting with the family, you're talking to the client as much as possible. And you're trying to avoid the harm of them being in prison any longer.
I think Rule 1.14 also expressly invites lawyers to speak with family members when these situations come up, but encourages you to let your client be the one who makes the ultimate decisions when there's a conflict. And when you do have a client with diminished capacity, it can be helpful to approach them at certain times of day with family members on the phone. And so getting permission to speak to clients, family members early can also be helpful when they have capacity. And the other thing I'll just say on this point is that the statute, I don't know if we can go all the way back to that first slide, but I can just read it. Basically, the statute, when it says that someone can be appointed to have standing to represent an individual. So even if you aren't able to establish a normal attorney-client relationship because of their capacity, you could petition the judge to appoint you.
Okay.
So a bit different from a guardian, but there's that's contemplated, I think, in the law.
Yeah, and it's a good point about time of day. There can be good and bad days even, right? So Sometimes it's multiple conversations. Yeah, this as a continuation, the objectives are the client's decision, but you are certainly gonna have to consult with their family a lot of the time.
So is the issue that they would rather stay in prison if they can continue to get treatment than go somewhere where they have to quit the treatment? Is that what really raises the issue?
Yeah, that would be the main sticking point.
Sometimes that happens.
Yeah.
And if you're able to find a palliative care provider or like a hospice provider that gives palliative care where they're able to do concurrent like
Mhm.
levels of treatment, you might be able to address their concern, but they're not always easy to find.
Okay. That is it. I'm gonna pass this around. Please, if you're interested in being on this listserv, you don't have it, you know, no obligation to take the case, but if you want to be contacted when we have one, please sign up. And we do have a little time for questions.
Oh, no, it's good.
Yeah.
Yeah, it's great.
Yeah, I have a question then.
A quick,
Stop clapping.
when you file the petition, who's on the other side? Is it typically the DA's office?
Yeah.
Or is it always the DA's office?
It's always
in
the DA's
county?
office. In Philly, it's gonna be the alternative, what are they called?
Release unit.
Alternative release
ARU.
unit. It's Sarah Boyette, basically. And they try to work with you usually.
Counties, not so much?
No.
Shocker.
Yeah.
Well, if I can pontificate for a minute, the major reason behind these problems is that we had a whole lot of mass incarceration. We still goes on, but particularly in the 90s in my youth, 80s and 90s and aughts, where there are mandatory statutes on the books that give these people these incredibly long sentences. And these organizations are working to prevent that. So if you could support them, that'd be great.
Thank you. Yeah.
Thanks for
and
coming.
thank you everyone for coming.
Yeah.
And Glimmer of Hope too, there's medical parole legislation that would
Yes.
repeal this law and it would
Yes.
replace it with something much more expansive and humane. So something to feel a little hopeful about after this. And also the idea that you might sign up to take a case, I think is wonderful. So I hope you guys can sign up.
And if Commonwealth versus Lee, whatever comes out of that, there may be a lot of folks who are doing life who can get out. Gonna need a lot of lawyers for that too.
True.
Okay. Thank you.
I have a quick question. The document that said that from the DOC physician that states like this person has a year to live, have you ever, do you get that because you request it from the DOC physician? Or do they ever spontaneously or like
think
we've
they do.
diagnosed this person?
They have spontaneously done it, right?
Yeah. They're supposed to have a policy where they alert their counsel and the counsel finds a lawyer for them, but I've only seen it happen a handful of times.
Okay.
So usually what happens is someone will write to us, we'll reach out to DOC counsel, they'll ask the doctor will say, yeah, that's right, they're eligible, and then they'll start the process of giving us paperwork.
Do you all find the social work departments particularly helpful? No, no. Just
At the
really
DOC?
good. Yeah, in the particular institution, no. Mm-mm. Okay.
Alrighty. Take more food.
Thank you.
Thank you all.
Thank you, that was
Thank
great.
you. Can I borrow your pen?
Francis, what you wanted a release for volunteers?
Oh, yeah, so we were talking about how to, if we receive documents, how can we like refer them to a different lawyer? And Rana was saying that you might have a form for it, but I don't know what she was thinking
Yeah,
of.
she was thinking about something altogether.
Okay.
I thought she wanted the confidentiality agreement for volunteers.
For you guys.
Yeah.
Because he like
Okay.
tries to keep in touch with all the people.
Those are mainly non-lawyers and also.
Okay.
Sure. it is.
Like, it's not too bad right now.
Oh, if you want to just leave these.
Yeah.
Yeah.
You know what?
You familiar with them?
Oh,
Sorry, they were like at
Yeah.
Phoenix, and I think they
Just
sort of
going
like
over.
elders.
Going away.
Yeah.
Yeah.
So, like, almost like Williams.
Oh, goody.
Anything you need, anything like that.
Oh, absolutely, yeah.
Glad that one-
Yeah, wait for
glad that one worked out.
Yeah.
I was sitting right by.
So out of
Okay.
pocket,
Yeah.
it's not like the prison
A little
characters.
different.
Yeah,
than
you guys
that.
fabulous.
Oh, thank you. It was an interesting party. I enjoyed junk a lot.
Oh,
Yeah,
thank you
that
so
was,
much.
that was fantastic.
Yes.
Oh, with our wonderful Rhonda who we love so
Yeah,
much.
yeah, yeah. Yeah, man, I'm still thinking about how strong that guy
Of
was.
course, yeah, I don't think I chance to meet
No, no.
you.
Up there twirling.
Yeah.
All right, thank you. It was good.
Appreciate you hosting us.
You run across somebody that doesn't have to be the condition.